Good afternoon. So very happy to be here today. Thank you, Jadek and Cressy, for the invitation to join the panel. I'm also very happy to share this table with Alexandre, Lazar, Diogo, Nicolo, and Svetlana. Hello. Here there. First of all, I'd like to, maybe for the fourth, fifth time in public, to congratulate the Ministry of Finance and all the secretaries and technicians from Secretariat of Economic Reform in the person of Alexandre here today. This process was conducted with a great institutional responsibility and diligence by the Ministry, and was very well received by CADE, and I am supposed that by all the stakeholders and academics. It was a relief to see how this subject was treated by the Ministry and conducted by the Ministry. And this is because we believe that listening and dialogue with all the agents involved, and public and private, is essential for building the institutional framework we need. I also would like to say that the Ministry of Finance report came at a crucial moment, of course, in the debate, not only in the economic and competition perspective, but also thinking about the other impacts that the dynamism of these sectors, if it's functioning well, it will give to our economy. And also I would like to say that the report and its proposal were very much aligned with CADE's view, as articulated in CADE's contribution to the call for contributions that Alexandre mentioned. So to talk about a little bit of CADE's contributions, as well as the report, it addressed the uniqueness of digital platforms, emphasized the difference between digital ecosystem and traditional regulated sectors are essential facilities, and of course, defined that in these ecosystems, the central platform doesn't just act as a provider of a specific services, but as an orchestrator of multiple interactions and activities. We worked, and as we or us, I say a super good team that we have in CADE. Some of them are here today, on the idea that digital platforms and ecosystem introduce new dynamics of value generation and appropriation that go beyond traditional analysis, requiring changes of antitrust tools. We brought a lot of economic ideas that Alexandre has already been explored here, but the main point is that ex-ante regulation can help reducing artificial barriers to entry, risks of tipping, and fostering for a more competitive and dynamic environment. Thus, rather than focusing exclusively or mandatorily access to critical resource, the regulation should pay attention to the data flows controlled by platforms and internal governance mechanisms that structure the market or the ecosystem space. So of course, it means that for us, it's necessary to pay attention to strategies that are designed to preserve platform dominance. And finally, in relation to the proposed model, we do agree, and I can say we because if it's in the CADE's contribution, that we need for an ex-ante, asymmetrical and flexible regulatory model, and also complementarily to the exposed analysis. So maintaining the exposed analysis, the exposed enforcement, without abandoning proactive and continuous intervention to prevently guarantee the proper functioning of digital markets. So this means a very important thing, that what we are saying here is that we do need an exempt model, but when we talk about flexibility and adaptability, and we are saying that we're gonna be able to, with this model, to individualize adjustments and to continuous monitoring. So it means that this model is more in favor of ensuring agile interventions and also sensible to local peculiarities and priorities. And also means that I do believe that what it's being proposed is a kind of ability to tailor interventions in a more balanced way. So when you say allowing to suit the obligations to the gatekeeper or its services, what we are saying is that we can tailor and go more into the specificities of each gatekeeper. Finally, I want to just make two short final points, and that I think it's very good opportunities for us to think as practitioners and academics. So I think that this proposal recognizes that first, regulation and innovation can and must live well together as a happy family. I think that both documents also recognize the importance of digital for innovation and for competitiveness and productivity of the Brazilian economy. I also think that when we are recognizing that there are particularities and we should not see competition or see gatekeepers or digital services as a single concept, and we are able to look at this more individualized, we are also recognizing that we have differences, for example, innovation processes for each one. So this means that the engagement that you were saying with stakeholders, negotiated initiatives, which permits in-depth knowledge of the specificities of services, technological and market peculiarities, and strategic aspects are being considered to be very important to the successful of the proposed regulatory policy. The another opportunity that I can recognize is that the moment that we are living, and also the way that the Ministry of Finance reacted to it, emphasizes the value of the competition policy and the regulatory policy as a state policy. So for the competition policy, it means that we are, I hope, and I think we should see a less insulated policy with analysis increasingly connected to the realities of the markets and also connected with other policies and economic drivers connected to competition. So it means that due to the complexity of digital platforms, which operate across multiple sectors of the economy and with all the implications that we have already seen, the policy will naturally be connected with other sensitive areas such as data protection, consumer rights, innovation policy, industrial policy, and competitiveness. So it will necessarily require continuous dialogue and broader integration with other regulatory areas. So we are going to have a very long path and funny and very excited year with a lot of discussion and work. And thank you very much.
Thank you, Camila. Well, first of all, I would like to thank CRECE, the Federal University of Rio, and especially Professor Pontual Ribeiro. I don't see you. Oh, hello. For inviting me to speak in such distinguished company. I would also like to thank the audience for sticking around till the very end. I promise that I will try to make this last session as quick and as painless as possible. For the sake of clarity, I'd like to break my opening remarks into 3 parts, with the understanding that we will touch on the concrete proposals by the Ministry of Finance later during the roundtable. First, I'd like to give you a brief overview of the regulatory landscape around the world. Ever since the EU announced the Digital Markets Act, or DMA, there's been a lot of buzz about the regulation of digital platforms. It is safe to say that this buzz has not died down with the entry into force of the Digital Markets Act earlier this year, in fact, quite the opposite. And while there has been a spread of similar regulations around the world, I think it is important to put this into context. Currently, only 4 jurisdictions have enacted similar rules for digital platforms. The EU with the Digital Markets Act, the UK with the Digital Markets Competition and Consumers Bill, DMCC, Germany with Article 19 of the Competition Act, and Japan with the Smartphone Act. This was the most recent addition. Granted, other countries are considering similar rules. These include Australia, Brazil, South Africa, India, Turkey, and South Korea. But it is far from certain whether all of these rules will pass. Some, like Australia's, look more likely to pass. Others, like the US's ICOA, OAMA, and Access Act, seem to have been abandoned completely. It is not impossible that the Trump administration will resurrect them, but it doesn't seem completely very likely. South Korea recently abandoned plans for a comprehensive ex-ante regulation in favor of a lighter amendment of the Competition Act that incorporates presumptions. It is not certain either when or whether India's draft digital competition bill will pass. Similarly, Turkey's amendments of Law 4054, Turkey's Competition Act, are currently on hold due to the political situation in that country. So my first point is this. I believe it's too early to speak of the existence and much less of the inevitability of a trend toward digital competition regulation and away from existing competition law framework in the digital economy. Further, even amongst the countries that have passed or are considering passing such rules, there are important variations that question the existence of a clear consensus. Which brings me to my second point. A tentative taxonomy of digital competition rules. The different regulations and proposals that have been put forward can be organized in many ways. I've thought of 2 possibilities. The first is functional, and it is blanket rules for all covered companies and core platform services versus bespoke rules adapted to each individual company and core platform service. The clearest example of the former is the Digital Markets Act. The latter is represented by the Digital Markets Competition and Consumers Bill of the UK and the proposal of Brazil's Ministry of Finance, and I believe also PL 2768, which was an earlier iteration. Blanket rules, of course, have the advantage of being more predictable, but also more rigid, which would be the downside. On the other hand, bespoke rules are more flexible, but arguably more discretionary and perhaps less predictable. The second classification is by their legal form. But as I will explain in a second, this is far from just a question of form. To the contrary, it tells us a lot about the substance and the underlying principles of this new animal that I call digital competition regulation. Currently, digital competition rules can be classified into, I would say, 3 categories. The first is those that constitute a separate legal instrument that disavow competition law objectives, such as the Digital Markets Act, and which claim perhaps to be complementary but different from the competition law. A second category is formed by those separate legal instruments that claim to be aligned with competition objectives, though sometimes with an increased emphasis on fairness, such as the DMCC or the Smartphone Act in Japan. A third category could be comprised of those rules that form part of existing competition rules, such as Germany's Article 19A and Korea's amendment of the Fair Trade Act. This raises an ontological question. Are digital competition rules competition law or something else? And if so, what? This is my third and final point. And that point has to do with the foundational questions which I think digital competition regulation research must answer moving forward to ensure that this exercise is as rational and well-informed as possible, rather than a knee-jerk reaction to perceived trends. The first and most essential question, in my opinion, is, as I have already mentioned, ontological. What is the nature of digital competition rules? What do they seek to achieve? Do they seek to protect competition to the ultimate benefit of the consumer? Do they pursue equity and fairness? Do they pursue free or fair competition? The two are not synonymous and can in fact be at loggerheads with each other. Are they concerned with leveling down gatekeepers that have become too powerful? Do they target a market failure or a moral failure? Let me show you what I mean. The Digital Markets Act, for example, expressly disavows consumer benefits and economic efficiency as irrelevant in either a showing of harm or in claiming an exemption. The DMA, after all, is about fairness and contestability, not consumer welfare. Article 19A of the German Competition Act, on the other hand, is couched in the German Competition Act, and as such presumably pursues the same goals: protection of competition to the ultimate benefit of consumers. The same can be said about Turkey's reform of Law 4054 and South Korea's reform of the Fair Trade Act. The DMCC, on the other hand, was touted as enhancing competition and benefiting consumers, but it also pursues fair dealing, open choices, and transparency. PL 2768 pursues competition and consumer goals, yes, together with regional equality and social participation. The South African Digital Platform Study emphasized the goal of leveling up historically disadvantaged peoples by giving them preferential treatment on some platforms. We can ask a follow-up question, which is, if these goals are distinct from competition law, will the logic of digital competition rules remain contained to those markets, or will it eventually seep into others? This question has as much to do with political philosophy as it does with the law. The second, and I will finish with this, pressing question which digital competition regulation must ask itself has to do with the cost-benefit analysis. What are the expected benefits of these rules, and how will they be measured? This, of course, has a lot to do with their objectives, which is the previous point. Will success be measured by the dissipation of market share of the incumbents, by a reshuffling of those market shares, by the number of entrants, by access seekers' degree of satisfaction with the terms offered by incumbents, by the effect on total output or on consumer satisfaction, all of the above, something else? In terms of costs, I really think that these need to be carefully evaluated, and so do unintended consequences. What are the costs of pursuing these goals? How could they affect incentives to innovate and enter adjacent markets? What is the cost of enforcement? What could the effects on consumers be? In sum, what is the likelihood and cost of errors compared to the but-for scenario under the existing competition law framework? Thank you very much.
Good afternoon. First of all, thank you so much for having me here, Professor Luis Carlos Prado, Professor Eduardo Pontual, Professor and Commissioner Camila Cabral Pires-Alves. It's an honor to take part to this rich and important discussion on the way forward to digital platforms regulation in Brazil. I appreciate having this opportunity after listening to Alexandre, who presented a very interesting proposal, insightful ideas on how to structure a new regulatory framework for Brazil. And although this is really timely and necessary, it's also something that comes with several challenges and implementation tasks. Brazil and Brazilian policymakers, as we all know, are in a crucial and historical moment in which the challenge of designing a new regulation regime and framework for digital platforms, the study in that context presented by the Ministry of Finance is therefore very welcome, but as I said, filled with several tasks and measures to be taken. As we know, the devil is always in the details. Sometimes the devil lives in the Congress. Sometimes he lives in the Centrão. We can always benefit from foreign attempts and efforts. We have seen that European initiatives, the DMA, the UK, the German and Japanese recent legislation serve as examples and benchmark, but there isn't much to draw on so far, because the challenge is really new. The type of instrument that the Brazilian proposal demands or foresees requires a great deal of legal and institutional imagination. This is a great opportunity, but it's a very risky one too. As Alexandre remarked, there are many things to do, and if CADE, the Brazilian Antitrust Authority, is the institution chosen to host the new regulatory framework, it necessarily must be reinvented to that end. This is not enough, however. A new law has to amend the current competition law and has to be enacted. This is not easy at all. Political resistance has to be dealt with and has to be overcome. Not only the economic power, which, as we know, turns into political power of big digital platforms, has to be taken into account, but also there is a pressing need to listen to other voices. Consumers, civil society organizations, small business, academics, and other stakeholders are to be listened and must have their voices secured. This new regulatory framework has to be protected from political capture. CADE has a long and embedded autonomy which has to be shielded. CADE cannot be captured unduly and unfairly by politics, in the bad sense of the term. Has not to be, there is no room for politicization in that sense. And beyond the political burdensome and unpredictable process, there is also the very difficult task of designing a framework that is ultimately able to strike a balance between competition, innovation, consumer protection, and other constitutionally protected values and rights. To do this, to fulfill such daunting tasks, state capacity is necessary to design new rules, do's and don'ts, and to regulate the largest corporations in the planet nowadays. This is key. And state capacity in that sense means defining first, what does it mean to create ex-ante regulation to prevent anti-competitive practices that hinder competition? To answer the question on are those ex-ante rules going to be flexible or rigid? To answer the question on what's going to be subject or who's going to be subject to asymmetric regulation, to answer the question on how to designate who is subject to asymmetric regulation. From the institutional viewpoint, challenges have to do with the need to transform CADE into a regulator and a competition authority at the same time. In other words, CADE will have to wear two hats simultaneously, and that requires employing very different types of tools with different purposes, although all of them concerned with competitive markets. Sorry. Is CADE going to create a new unit? How? With what status? How will CADE work once the new law is passed? How CADE as a regulator will interact with CADE as a competition authority? How digital cases, so-called, will be defined? Is there going to be any type of institutional coordination with the central bank, with the data protection agency, with the telecoms regulator, with the Secretariat of Consumer Protection, Senacom in Brazil? Big techs have been arguing that regulation tends to lessen competition and to hinder innovation. They already criticized the DMA on several instances. Some of that criticism may apply and may be valid, but not all of them. That might be true that DMA has problems, that DMA can be perfected, but it's not true that regulation and regulatory reform are per se bad things or ill-conceived. As Camila was stating before, smart, well-focused, flexible, adaptable, and revisable regulation to countervail the enormous economic power of digital platform is possible, but it takes a lot. CADE has been a competition champion, a respected authority worldwide. And if things move as expected, CADE will have to reinvent itself to innovate regulation. This cannot be taken for granted. Not only the federal government must do its job, but also the Congress has to take responsibility to digital platform regulation. And this is not about partisan politics. This is about state policy. To sum it up, all depends on how we do it. Regulation can live with antitrust, as also Camila was stating right now. And the new hybrid instrument proposed by the Ministry of Finance is very promising, has great chances of success, but there is no guarantee that's going to work whatsoever. We have to remind that bad regulation can be worse than no regulation at all. So the challenge is immense, but Brazil certainly wants to get it right. So let's hope that the process, Alexandre, will flow without much intervention, without distortion. And I hope that the Ministry of Finance can conduct it as competently as it did so far. Thank you very much.
Okay. Can I have my slides? Okay. Thank you very much. It's a pleasure to be here. I want to thank the organizers for this wonderful conference. I think that's not, so should I go, because the slides are hers. Should I go? Okay. So it's not that, yeah. Okay, I'm not going to speak about digital platform in Russia. No. Altro. As you wish, if you want. All right. Well, again, thank you to the organizers, and it's been a very interesting conference. I've already learned a lot. Here, I'm going to present to you a proposal that was built upon this very interesting report prepared by the Ministry of Finance. I also want to congratulate for the excellent work they have done, and for also to CADE for participating very effectively in this discussion. You can download the paper. The QR code should be working. This is a very initial draft that I've developed with my colleague Artur Sadami, who is here in the audience. We just think that it's important to also get concrete on how we can implement this framework in a way that aligns with some of the principles of regulation in dealing with digital technologies. Thank you very much. So the first comment that I want to make is the OECD has developed some principles released in 2021 on what they call agile regulation. So agile regulation is necessary when you are dealing with something that is very complex. You don't even understand the full nature of the problems and the possible solutions to it. So it's important to not use the traditional tools of command and control regulation, but open up to input of third parties. And this, I mean, of course, it involves a dialogue with regulated entities, but it also involves receiving insights from parties that are affected by the services of these entities. So it's very important to have this approach that takes into account all that, and takes into account of the relevance of different areas of law. So we know that nowadays many issues are not just competition law issues. They have to deal with consumer protection, financial regulation, data protection. So there are several issues involved. It's also important to have a dialogue with other authorities So that's what we promote here with the principles. And another important element is to recognize that you must evaluate periodically whether you're performing well with your measures that you're introducing. So it's important to have some eye for the metrics. You know, what Lazar was pointing out I think is very important. So what are the objectives of the regulation? How are you faring in achieving those objectives? And if you are not satisfied, you can go back and adjust the framework that you have developed. And it's also important in all this to realize that the authority doesn't always have the resources to monitor and understand, implement these measures. So it's I think interesting to consider solutions that are more collaborative also in that sense. So for instance, sometimes it is more effective to develop a code of conduct and rely on a framework where you can have transparency and accountability over the implementation of this code of conduct instead of applying immediately a draconian measure that perhaps can not adequately address the problem in place. And also you can rely on third parties, auditors, experts that assist the authorities, particularly in the implementation of the remedies. And also academics, by the way, which is good for all of us. So this is the framework that we propose. It's a 4-stage framework, integrating the two aspects that were proposed about market study and market investigations or pro-competitive interventions. So at the first stage, there will be some identification of relevant services that would need to be studied by the authority. And here, this first study will be based also taking on the work that was previously done. So for instance, if the authority has done a lot of investigation, a lot of cases with regard to a particular market, as it was suggested in the Draghi report, it could take into account all the evidence that it has collected in these cases. It can also take into account the evidence of market studies developed in other jurisdictions or the experience of other authorities that have dealt with these players, these particular services. Then it would publish a notice about the intention to target these services, and it would open up for third parties to react and suggest that maybe this scope should be adjusted. But then after having received these comments from third parties, you publish the final notice of the target services and you start a market study. So you conduct this market study. At the end of the market study, you reach a conclusion about the level of concerns that you have in this market. So if it's a low level of concern, you don't need to go to the next stage, which will be a market investigation. If it is an intermediate stage, then you would suggest measures that are more based on transparency, as the report has suggested. So one measure that you can apply to all the systemically relevant players is transparency. This transparency could be also about the measures that are undertaken by the digital platform in question to address ecosystem failures, to address the problems in this market. So if you can commit to preserving a safe and innovative, friendly environment, then we are, for the first period, satisfied with these proposed solutions, and we will monitor how they will fare. In the second stage, there will be a re-evaluation of this framework, so you can then raise the concern to more serious concern, but also if the market study recommends that already that there are very strong concerns in the market, then you go for a more robust intervention. And this process where you define the obligations is also including a part where you identify what are the key agents in these markets. And this might have something to do with these systemically relevant players, but it can also be separate from that. I will talk about this more in a second. This just to give you an idea about the first stage. So the first stage, as I told you, there's a technical note that will be published a contribution for third parties. After that, another 30 days, you publish the final note. And finally, there is a decision by the administrative tribunal on CADE on the list of targeted services. Something I did not mention is that all this will be developed by a special unit, as was suggested in the report, that is the unit on Unidade de Acompanhamento de Mercado. And this unit will have to publish a decision, a proposal, but the final decision will be adopted by the CADE tribunal by majority voting. Then in the second part of the study, yes, we will publish the final version, and you pass to the market investigation. So in the market investigation, again, you publish a technical note defining who are the key players, and this definition of key players, it's something that we should discuss, what are the criteria, but preliminary we would suggest that these key players are those that can unilaterally make decisions that affect the whole ecosystem, the whole players, the value of the ecosystem. And then you allow third parties to submit their interest to participate in the process and help the regulator. So in the first 30 days, you allow these submissions. Then you end up with the designation of the players. Finally, there's this process of definition of substantive obligation, which arguably is the most tricky and most evidence-driven part, where you really need to define what are the appropriate remedies for the problems that you have identified in this market, which is different from the one-size-fits-all solution of the DMA. Again, you have a final decision by CADE. One point that is interesting in this one is it's a periodical evaluation. So in the first year, you do the market assessment. The second year, you would have the market investigation. Then you go back the following year while you are applying these obligations that would last for a period of 2 years. You also do the first step again. You reevaluate the market. You evaluate if the concerns are still present. And you have in the second phase, you might want to redefine new obligations on the basis of the second assessment of the market. And so on, you continue. So I think just to conclude, this is a blueprint. It's very much open to debate. We put it out there to try to focus on some key questions. So one is, how do we define these key players and what are the criteria? Another important question is the margin of discretion that the authority has. To what extent can you appeal the decisions? Do we need to have like a marginal judicial review, which would encourage the authority to develop a more effective framework? Or do you want to subject every decision, every one of the technical notes and decisions that we have seen there to possible appeals, which might delay the effectiveness of implementation of this framework? What kind of mechanism you have for collaboration between different authorities? One framework that is useful here is what has been suggested in the Meta case in Europe, where the data protection authority must be consulted if the competition authority thinks there is a data protection relevant question, and they must give a time to respond to these concerns, and then they have to implement it, basically. And finally, what kind of relationship would this framework have with traditional antitrust? And here, I mean, of course, you cannot say that if you open a proceeding, you cannot have any antitrust action. I mean, it's one position, but I think a more sensible approach is to recognize that whoever is collaborating with the development of this framework should not be punished for having done something that the regulator has suggested. And also, if you are punishing a company for antitrust infringement that relates to this collaboration with the regulator, maybe the fine, the sanction should be taken into account, this cooperation. In conclusion, it's important to address this point, but I think it's a very timely moment. And I want to bring, just to finalize, an example from today that I think is very relevant. Today there was this preliminary measure imposed on Apple in a case against Mercado Libre. It was about the fact that Mercado Libre was offering streaming services to their frequent customers, and Apple would not allow Mercado Libre to do that because in order to offer any streaming option, they want their customers to pay the 30% fee that Apple charges in their ecosystem. So here, a first approach would be show us, Apple, that this framework that you have in place addresses the ecosystem concern, and it's a fair one. It's not something that you are applying discriminatorily to Mercado Libre as opposed to others, or to products of streaming as opposed to other types of apps. If you are satisfied with this solution, you don't need to go with a very strong, intrusive intervention. But a second step, if you come back after 2 years to reevaluate this framework, you might want to say, no, it's not enough. You need to give interoperability. What CADE imposed today, you need to ensure that there are other distribution channels, not just the Apple App Store to distribute streaming services. But this still might not address the whole problem, because you have also data appropriation whenever you do the payment. So you might have a concern with the amount of data is being collected by Apple. So a third obligation that can be imposed at a later stage, maybe in the other cycle, is also, I don't know, data sharing or some aggregate data sharing about the payment transactions that are conducted in the ecosystem. So this was just to give you a concrete implementation of this framework. With that, I think I exhausted my time. I thank you very much.
So, may I ask to open my presentation as well? Yeah? Thank you. And first of all, I'd like to thank for inviting me here and the opportunity to participate so interesting discussion and to hear different opinions. A lot has been said already about approaches in US, Europe, Japan, Korea, Brazil, of course, and I'd like to, well, cross-country comparisons are very interesting and useful, so what I'd like to do is to give you some ideas on what's going on in Russia, as nothing has been said about it. So, digital platform regulation is Russia, started to develop not so long time ago, actually, and it seems, I need this one. And it seems that the first authority that recognized the need to develop new approaches to analysis and investigation of digital platforms is Russian Competition Authority. Reading text of decisions of antitrust cases against digital platforms, we see that approximately before 2017, there was no understanding, no sign that FAS recognized that this business model is very different from traditional markets, as traditional tools were used for analyzing this business activity. And starting from 2018, we see that market analysis includes understanding of the concept of multi-sidedness, network effects, big data analysis, and so on. And this particular time, Russian Competition Authority recognizes that some amendments to Russian competition law are necessary because the tools didn't fit requirements of antitrust in digital area. So what you may see on this slide are actually some ideas that FAS presented in 2018. And they came under discussion. So these are suggestions on amendments to Russian competition law. And I would say that they would be extremely restrictive and they would give extremely high enforcement power for Russian Competition Authority. Here I need to give a small note. The specificity of Russian competition law is that according to our norms, many business practices of a dominant company are presumed to have anti-competitive effect. So actually, if a dominance is proved, it might be enough to consider about any business practice that harms consumers or competitors as abuse of dominance. And this should result in corresponding behavioral remedies. So, for example, the first point, well, if you can see on the slide, the first point was suggestion to qualify strong network effects as a sufficient condition for dominance. What would this mean is that FAS would have absolute power to affect all business practices of all digital platforms. So the same can be said about big data analysis. One interesting suggestion was to consider any merger in which digital platform is one of the sides as a subject for competition law enforcement. So irrespective of market shares, irrespective of the value of assets involved. So quite soon, business society and other regulatory bodies recognized that that could be extremely restrictive amendments, and actually 6 years later, when the fifth anti-monopoly package was approved, these suggestions didn't we were not a part of it, and only one position was approved, actually. But what is great is that the initiative of FAS and following discussion resulted in other changes in Russian legislation. And we do not have anything similar to DMA. Instead, particular norms of industry-specific regulations are developed and they are focused on particular problems that might appear in different sectors and that are related to digital platform businesses. I'd like to give just 3 examples of what is going on. First is amendments to the law on consumer protection that appeared, that came into force on 2022. They are actually a result of antitrust case against Apple. So according to the law, these days, compulsory pre-installation of domestic software on all devices to be sold on the territory of Russia is required. So the list of applications is developed by Russian Federation government based on the rating of the Ministry of Digital Development. And this list is quite wide. It includes search engines, messengers, emails, payment systems, and so on, so on. A lot of points. And one more point is that it is required that any piece of software, any pre-installed application is to be removable. So in public we name it anti-Apple law. So this second example, following the results of antitrust investigation of business practice of Yandex search engine. It was actually a business practice aimed at self-preferences with the use of recommendation systems. So following this case, amendments to the law on information technologies and protection of information were approved. And again, these days, owners of information resources that use recommendation technologies are obliged to publish information on the data collected about users, on methods that are used to analyze the data, on methods that are used to create recommendations. And we have a specialized regulatory body, Roskomnadzor, that has a power to restrict access to any information resource in case it fails to comply with the requirements. So I'm not sure this might help to solve the problem of self-preferences using recommendation technologies, but it is actually one step in this direction as it becomes clear what is inside algorithms that are applied. Before this, it was not clear. And the last example, sorry, I changed. That are recommendation technologies, sorry. And the last example. Well, anyway, I'm not sure that you can see what is on the slide. And the last example, it's not actually a result of some antitrust case or investigation, but it's a very good example of the general vision of Russian regulator on obligations and responsibilities digital platforms should take. So it was 1 year ago when amendments to the law on organization of passenger and baggage transformation by passenger taxi in the Russian Federation, well, taxi services, came in force. This is actually, so what platforms actually do? They develop rules of game through which their users should follow when transacting through the platform. So actually these rules of game, or institutions, following the rules of institutional economics, they might be developed in the way that help solving some problems that appear at this particular market. So what Russian regulator tries to do is to enforce digital platforms in Russia to do something good for the society. And the example is taxi service regulation. So amendments were aimed to, were focused on taxi aggregators, obligations of taxi aggregators. So these days, they are obliged to control that taxi drivers have a corresponding license. So it is very easy to do because there is a centralized database, so access to this database is easy for platforms. Second, taxi aggregators are obliged to control that taxi drivers do not work more than 12 hours a day. As it was a huge problem, the taxi drivers tried to work as much as possible, get a lot of money, they became tight, and there were a lot of accidents. So now, taxi aggregator can just automatically stop sending orders to them, and they are obliged to do this. And the last interesting point is that when taxi drivers get into an incident and the insurance does not cover the damage, taxi aggregators are responsible to cover the rest. This motivates this type of digital platforms to control that taxi drivers have this insurance. So that is the idea, that the quality of services provided by platforms are regulated in Russia. So something similar is under discussion these days in relation to marketplaces. Again, there are some ideas to make them responsible for the quality of goods and services traded through them. And there are actually 2 draft laws under consideration, so there are different ways to do this, but I think I do not have time to talk about it. So to conclude, what's going on in Russia is, well, according to my personal opinion, we move from competition policy regulation, policy enforcement, which is ex post, to ex ante industry regulation. And this regulation is really industry specific because there are different problems in different sectors that require different solutions. So that's what I wanted actually to say. Thank you.
Well, we have some time for questions.
Thank you. I would like just to raise a point that Diogo Coutinho raised that is interesting to think. Anyone that had experience to accompanied the law, the competition law of 2011, know how it's difficult to change competition law and go to the Congress, and how it's let me choose the correct word. It's delicate because you have one aim and this can and another aim very different. So for me, what to be wise do is not to change the competition law, but propose a new law specifically for the other market. Because if you open the debate on the competition law, a lot of points that was very hard to get, I give you an example, the finance. You know that the way that the fine is calculated is a little bit difficult to, it's not so clear in the law. This was the result of a last moment debate on the Congress. So I think that is very interesting, and I'd like to congratulate the work of the Alexandre Rebêlo Ferreira and his group. Was wonderful work, very interesting, creative, and for many ways is interesting for the Brazilian health. But I agree with Diogo Coutinho that we have some issues that we have to take care. And when you open this new area, you have to think very well how this is going to be done in such a way to not to make the CADE weaker, not stronger. And this is not linked to the quality of what was suggesting, but the way that the law is going to be approved. What kind of thing they are to put there, and how the governance mechanism going to be seen. So it's just a comment, and as I have lived and worked in the 8894 law and the old law, and accompany a little bit the debate to approve the new law, sometimes what you want to choose you can't get, because it depends on the situation in the Congress in the moment that the new law is proposed, and no one controls that. This is very difficult in Brazilian reality.
Some other questions we can.
Well, so Professor Luis, I think those are very, first of all, thank you very much for the compliments. Those are very relevant remarks, I think, that you bring here to the conversation. Because, yes, we are very much, we are aware that we need to have, first of all, we need to be very much clear on the scope of what we want, so as to preserve the specific, this debate that we're conducting in parallel to the other legal instruments that are already in action, already in place, that have already been discussed, that we don't want to open a broad discussion about the competition law or legislation. We want to be very much focused and be able to rely on the technical aspects that are supporting. Of course, that while designing this proposal and now turning it to, we are at the moment of turning it into legal text. So we are preparing the legal, the draft that's going to be debated further on in Congress. We are taking into account, I think, that the current reality that we have in Brazil. So at the Ministry of Finance, basically our role is to promote and implement reforms that are either legal or infra-legal, sometimes resolutions from the National Monetary Council, decrees, resolutions from the minister, and sometimes legislation. So we have been having quite an experience over this past year almost 2 years in dealing with the Congress that we have today. And so there are challenges for moving forward and for convincing the congressmen and congresswomen at the lower house and then at Senate to move ahead with the legislation, following those data-driven points that for which we are advocating. But on the other hand, we strongly believe that the way we are building the political message here and the way in which we intend to have it reflected in the text, we think there is room for building consensus across the political spectrum. So what we are doing, and we are being very much specific here, it's on digital markets. We don't want to have a broader discussion on competition policy, on antitrust mechanisms. And we also don't want to this is not a conversation about, say, content moderation or even taxation, right? So of course, we are in connection with other subjects being debated in government and other very much hot topics in Congress regarding the digital in a broader sense. But we think that by having this being focused and by demonstrating the role of promoting competition and the importance for local businesses in Brazil that rely on those services, we think that we can pave the way for this challenging task, which is to pass the new legislation. But on the other hand, we think that there is room for the legislative to receive this message and to build and then to build this dialogue down the road. But we think that by starting, we have been studying for 2 years before presenting this this proposal, right? And we think that by doing it in a data-driven, evidence-based way, we think it's easier to sustain those measures. But yes, there is a challenge ahead of us, and that's why we also think that for cases of platforms that are not classified as systemically relevant, that are that have a smaller degree of complexity, there are some things that could be done within the current legislation. So I think that's group 2 of our recommendations that regard the notification procedure, eventually the development and adoption of a few new theories of harm to deal with the data dimension of market power and so on. But yes, there's a challenge, and we are deciding to tackle that challenge because we think it's necessary and because we think there's room to build consensus across the political spectrum. So in a nutshell, that's the response here.
I'll try to make it from here. First, well, one quick comments is that thank you for mentioning my name on the invitation, but I'm just the figure that you see and made the call. Actually, it's from the full committee, organizing committee that we did here. I have one question and two questions, if you allow me. The second one will be more throwing ideas up and asking what's your opinion, particularly the Brazilian ones. I think that both the Microsoft case, of course, in the US, has been very informative of what kind of structural or conduct remedies can do to increase contestability. And if you could explain a little bit more about the Android case in Russia, I think it's also something that I remember that can be also informative, that it required to have local platform, local software appearing also on the app stores and on the default of the software of the system. And the second question, which is more general, particularly although coming from an economist, that probably that's why I'm asking. I think that if we think about the economic order, which is the constitutional mandate that generates the law of competition. Do you believe that it's broad enough to include not only consumer welfare, as CADE has been there and have done that, understands what the competition law is, but also contestability and fairness, which it seems that in Europe they have to adjust to or go sideways. But is our legal framework broad enough from the idea of economic order to account for these different views of what the market should work and thinking about regulation of digital platforms?
Hello? If I understand your question correctly. Actually, what I told was about anti-Apple law, not anti-Microsoft law. But the idea is actually so that it was not possible to. So many applications of Apple were pre-installed and were not removable at all. And it was a big antitrust case in Russia, so it was found guilty in creating barriers. And remedies imposed were to provide access to the operation system so that alternative application could be installed. But rather than to keep it as an antitrust case, as an antitrust sphere of interest, what is done in Russia is an industrial organization is developed, actually. So, and it's a law on information technology, information and information technologies. So, according to that law, to industrial regulation, it is obligatory for all companies, not only for Apple, for all companies, for all to allow pre-installation of different applications, including Russian ones, and to provide competition between applications. It is required that, well, there is a list that can be decided by the company, but there is a list prepared by Russian authority, by Russian Federation government. So, and this list is updated annually, so depending on the ratings of applications. So something like number of users that, like, so on Facebook or WhatsApp or whatever. So, well, we have some Russian equivalents, but you do not know the name, so I do not mention them. Well, and so what we have now is that there is a list of software, there is a list of applications that should be pre-installed. And if some devices are sold without pre-installed Russian applications, it's a matter for financial penalties for companies and for particular persons. Well, and when you buy the device with pre-installed applications, when you start using it for the first time, you can easily remove, well, keep what you like, remove what you do not like. You can install something extra, because Russian application store is to be pre-installed as well, even on devices made by Apple. But they are not sold in Russia these days.
I know I wasn't called, but I just have to speak. You mentioned the Android case in Russia, which I'm not familiar with, but as a parallel, you mentioned something about pre-installing or preferencing Russian apps or results, if I'm not mistaken. I don't know if we have any South Africans in the room, but and if so, please, correct me if I'm wrong. But the South African Digital Platform Sectoral Inquiry proposes granting the South African Competition Commission with certain remedial powers within the framework of their Competition Act. And two things stand out that are connected with what you said. One, digital platforms that are covered would have the obligation to preference South African small and medium-sized enterprises, particularly those owned by historically disadvantaged people. So the way this would presumably work is if you look for something in Google, there would either be a marquee or a South African flag next to a business owned by South Africans. Or for example, if you're ordering food on Take-A-Lot, which is a South African platform, small and medium-sized or independent restaurants that are South African owned would come up first. In addition to that, covered platforms would have the obligation to set aside a budget for training South African SMEs, and particularly those owned by historically disadvantaged people, to use their marketing sort of tools effectively, right? So maybe this is interesting to you based on what you asked in the Android case.
Eduardo, if I got your question right, I would say that our constitution and competition legislation is quite open to interpretation, and when it comes to the constitutional economic order, principles of economic order are so broad and vague. If you look at Article 170 of Brazilian Constitution, it's so open and keen to interpretation that whatever you want to argue would be possible in terms of combining whatever goals you want to assign to competition policy in Brazil. That's why our constitution is considered to be programmatic or principiologically designed. And I also think that the issue on what is the goal of competition, when you look at the Brazilian legislation, is also quite open to interpretation. So it's not something that you can anticipate or define upfront, or merely reading whatever you look at the law, at the legislation. So it depends on basically what CADE builds as its case law. It's not simple, it's not previously defined. So building a consistent case law is something that CADE has to do if it wants to really build a consistent interpretation on what is antitrust designed to pursue in the Brazilian law. And this is not something that CADE has done in a clear and straightforward and intentional way so far, in my opinion. Because every time commissioners change, every time CADE combines economists and lawyers, things change. That's good in a sense, but CADE does not think in a self-conscious way about the way competition should be designed as policy, as something that should aim at a certain end, whether this is consumer welfare or whatever. So this is something to be built, this is something to be designed, this is something to be conceived and consistently structured in a coherent and sustainable case law, which we don't have in my sense. I don't know if I got your question right. Thank you.
So thank you. I also want to respond. I entirely agree with Diogo that we will need more consistency on the interpretation of this jurisprudence, and this is a fact due to the heterogeneity of commissioners, and in the end, I mean, I think that this is not something that depends only on the jurisprudence of CADE, but of course the economic order is something broader. So you asked not if competition law has this values that it can protect. I think that contestability definitely it has. Fairness, it has some types of fairness, particularly exploitation of consumers can be put into that framework. But here we are talking also about exploitation of business users, it's a slightly different concept, and I think, as Diogo said, the Constitution is wide open. One thing for sure, we have national sovereignty as one of the principles there in the economic order, and I think this implies that we need to understand, to have more transparency. Sovereignty is about understanding, you know, and being able to use these services. So if you don't have transparency, you don't go anywhere. So I think the first recommendation of the report to have this horizontal transparency obligation is a quite useful one. I want to also take advantage of the fact that I have the mic to respond to the previous question, because I think a law would not in itself solve the problem because of the complexity of the scenarios that we are facing. So the key issue is reviewing over time. That's why I think the market studies are a good tool, because it allows you to experiment. Now, one point I wanted to note is that generally market investigations, as they are in, for example, Germany, UK, Iceland, various other frameworks, they are imposing, they can impose measures without any violation of the law across the market, so to various players in the market. What this proposal is suggesting that there will be a way to impose these remedies, but only to one specific type of player. So, and this has to do also, I think, with the political factor that you mentioned. It's very difficult to get approved in Congress, as we're discussing with somebody, everything nowadays, but particularly if you have something that puts in danger, let's say, various interests in society. So I think nowadays it will be very difficult to have a horizontal market-wide market investigation with the possibility to impose remedies. But if you focus on the key systemically relevant players, I think there is general understanding by everybody that we need something like that. And one point that I think is relevant also is I wouldn't put a safe harbor, let's say, on the companies that are not qualified as systemically relevant players. The market study would also allow you to designate ad hoc some players that maybe do not have high turnover, they don't have maybe these very high network effects that were mentioned as one of the key criteria, but they have some very valuable asset. For instance, if you have data that can be used across various services in a company that is not generating a lot of turnover yet, but has a significant potential as an ecosystem to affect various stakeholders, you might want to designate it or to impose some pro-competitive remedies, even if it didn't meet the original criteria. So I think this is also another point on which we need to debate, you know, whether this tool should also apply to, let's say, not the classic big tech, but for instance, even in a case of, I don't know, a local tech, health tech, you put, you know, there are many different types of ecosystem. You don't need to always talk necessarily about huge ecosystems. So that's another thought for discussion.
Any more questions?
I just want to add some comments. First, we are aware that we are in the middle of a big challenge, right? It is a very important challenge, and it's definitely not an easy task. And so, thank you for the speakers. Thank you, Diogo. You made a very aware and sensible speech about the challenge that we're going to face. And Nicolo also very nice, and thank you for suggesting an institutional design and also a procedure design with the market studies. I just think that maybe we should call them market inquiries, not to make a confusion with the yes, and I want also to thank for the opportunity to hear the comments and to highlight the necessity of promoting this kind of discussion among also among other competition authorities, civil society. I don't think that we are going to face this challenge without hearing all the possible opinions about academic, civil society, and everybody that really needs to help with their opinions. And on the principles design, the only thing that when an economist, the only thing that I would say is that what we can think about what's going to be the principles and the objectives that we are going to put in law, but what the main issues that comes to my mind is that we are agreeing that to promote competition and to put the policy, the public policy, more connected to the reality of these markets and these platforms. We need the ex-ante regulation and the ex-post competition policy working together. So I think that it's kind of goal that we are intending to face with these proposals. Thank you.
Any more questions? No. Do you want to make some final remarks? So we can close this round table. Thank you very much for the discussions.